record, everyone can have a seat. We're on the record of Woolard versus Clemens. Counselor, could you introduce yourself?
Melvin Grimes, bar number 12972, the Grimes Law Office for Mr. Woolard. Also seated at the table is Sean Akari, my associate.
Okay.
Okay.
And what's his role going to be?
He'll just be assisting if we go forward with the evidentiary hearing. If we don't, then he is slowly learning so that I'm no longer practicing in family court and can.
Okay.
So.
Does he need a legal pad or something, a pencil?
We're he
he
might. We'll see.
Okay. What's your motion?
Your Honor, we have a motion. Basically, we previously filed a motion to adopt the findings and recommendations of the Discovery Commissioner for failure to comply with discovery. We've submitted a motion basically to enter the default that was recommended. We still have no discovery from her. To this day, we have no admissions, no interrogatories, none of the materials we requested. We couldn't submit subpoenas. We couldn't subpoena records. Essentially, she stonewalled us.
So you want me to enter a default as a sanction for her discovery?
That was the recommendation from Commissioner Beecroft, and we would ask that you adopt it, enter a default, award primary physical custody to my client with appropriate out-of-state visitation. School starts in 2 weeks. Both parents have enrolled the young man in school at their homes, but we do need a decision, and it's impossible for us to proceed and put on the case that we need to when she refuses to comply. And you know, Commissioner Beecroft was clear. Her objections are waived. She's required to submit, and she simply won't. And I don't see that there's any other possibility.
A copy of the Beecroft decision?
I do. And the minutes.
Well, the motion to compel discovery was granted. Defendant must provide responses to outstanding discovery requests no later than close of day on June 20th. If defendant fails to respond to discovery as ordered, self-executing order shall strike defendant's answer and default shall enter. Plaintiff's awarded attorney's fees of $500 payable within 30 days. That's Beecroft's recommendation, if you want to call it an order. It's recommendation. Here's Discovery Commissioner's report and recommendation. I think it's probably just the same.
It is.
And this is what the Nevada Supreme Court says, Blanco versus Blanco. It is not permissible to resolve child custody and child support claims by default as a sanction for discovery violations. So how do you get around that? A very clear language from the Supreme Court. Have you read this case?
I've read parts of it. I've never read it in its entirety, so I didn't realize that that was actually the language in the decision. But I don't know that we can. But, Your Honor, we're faced with 2 weeks till school starts. At the very least, we've got to have an interim order for school. And if we're going to do this, we would be asking then to reset this hearing again. And then as sanctions, Your Honor, she should have to bear my attorney's costs for yet another.
Well, I didn't say that was not permitted.
No, I understand. And again, we aren't asking that she not be permitted to see the child. We can't put on the
trial. This is what they say, you know, the part maybe you didn't read. It says, with regard to child custody and child support, we determined that a case concluding discovery sanction is simply not permissible. These child custody matters must be decided on their merits. It is well established that when deciding child custody, the sole consideration of the court's the best interest. Child support awards are guarded by certain formulas. And then it goes on, and we have held in other contexts that A court may not use a change of custody as a sword to punish parental misconduct, such as refusal to obey lawful court orders, because the child's best interest is paramount in such custody decisions. And child custody decisions implicate due process rights because parents have a fundamental liberty, interest in care, custody, and control of their children. Other courts have similarly held that before rendering a default judgment on a child custody and support issue as a discovery sanction, the lower court must conduct an evidentiary hearing or consider other evidence in the record as to the child's best interest. Given the statutory and constitutional directives that govern child custody and support determinations, resolutions of this matter on a default basis without addressing the child's best interest and other relevant consideration is improper.
I would agree with Your Honor that it's relatively clear.
So I could grant you your motion, but we'll be back here in 3 months and you would lose on appeal. Which is okay for you, but I don't want to ruin my record.
Your Honor, honestly, we're not trying to harm this child. We're not trying to block visitation.
What discovery have you provided since you were ordered to provide it?
They're right here. I have a receipt. I mailed them on June 20th. I have from FedEx. I have the receipt in here. They're right here. I mailed them to both. They're filed within your system. I mailed them to the court, and I mailed them to them as well.
So,
I looked.
So I'm not in default. And the $500, the discovery commissioner suggested I pay. I actually called his office and tried to schedule a payment arrangement, and I didn't get a return phone call. And I also called the clerk of the court, and they said that I could pay the $500 by the 30th of August. No later than if you granted him the default.
So we're going to have the hearing. If there's specific items that you would like to object to as we proceed in the hearing, we'll do that. My understanding is the parties have joint custody right now. Dad lives now in Nevada and Mom lives in California. So Mom wants the child in California. And she thinks it's in the best interest of the child to be with her in California. Dad says it's in the best interest to live here. So we're going to go under the Potter standard. And there's also a new case, Drugman, that we need to look at some of the source factors as well that they have requested. It's her burden to prove that she has a good faith reason to move, and if she does, then she has to explain why it would be in the best interest of the child to live in California, and then you would have to explain why it's in the best interest of the child to stay here.
Your Honor, on that, we have not received any pretrial evidence, no disclosures whatsoever. I would, if we're going to proceed today, ask that all of her evidentiary admissions be stricken. We haven't had time to review them or anything, and we have requested, as part of the interrogatories, part of the request for production, was to provide all of it. We've received nothing from her.
Well, we're going to proceed and we'll do it one by one, but it's kind of hard to follow the directions of the Supreme Court to make a decision on the best interest of the child and to have a hearing and then say, we're going to have a hearing and then we're going to hang her.
No, I understand that, Your Honor.
Because if she's not permitted to introduce any evidence, then what's the purpose of the Supreme Court telling us to have a hearing?
Your Honor, I don't disagree. And I don't want to try my case in, pre-hearing banter, for lack of a better term. We have produced everything she's asked, okay? And I'll lay it out. My client had issues. He went to jail. That's what started all of this, okay? We have to show best interest. That is this weighing. She has refused to provide us the same information. We don't have it. Her claim that she mailed it, my office keeps a mail log. We don't have it. She says she filed it with the court. I checked this morning. It's not filed with the court. There's no opposition filed. How do I make that scale balance when two people have both in their past? And I want to clear that it's past. We're not talking, in my client's case, present. There is some with the defendants present that we would like to introduce, but it becomes evidentiary problems of hearsay that if she doesn't understand to object, the court at least does. I can't I can't subpoena the correct people to get it in. I know you said we'll do it on an item-by-item basis, but you're placing us at a substantial disadvantage given what we know she can get in regarding the plaintiff.
May I speak? I have an opposition I also filed to the suggestions made by the Discovery Commissioner. I filed that too. I have the receipt of mail that somebody else mailed it. They keep saying they don't receive anything. I keep mailing it. I don't know what else to tell
What
you.
address did you mail it to?
I mailed it a couple things to his own office, and I mailed a couple things to
What address?
to Robert's house.
The law office.
And let me look on the receipt of mail.
Where's the child now?
He's,
the hallway.
yes, and he also already started school in California. He's been there for a week.
3 days. Ah. That would be a violation of the joint legal custody agreement.
I'm supposed to keep him out of school if school starts.
Did you file a certificate of mailing?
Yes, that's what I filed.
What date? Was there a certificate?
6/20. I have to mail everything because I'm out of state. 6/20, and then one was in the middle of July.
Do you have any certificate of mailing on that?
There's two, and actually one of the persons that mailed one of them is in the hallway as well.
And to be clear, Your Honor, the only thing we have ever received from her is her opposition to the adoption of the hearing master's findings. And I checked this morning, it has never been filed, it's not there, and we have not received any discovery from her.
Well, the Supreme Court says you can't get a default.
I know.
So what sanctions do you want?
Well, honestly, Your Honor, what I would ask at this point is that we set a new trial date, that you direct her to if she has prepared the discovery, there's no reason she can't deliver it to my office today, and that she be required to pay attorney's fees and costs for this day forward. Mr. Woolard has paid me. This is the second setting of this, both of which have had to be delayed because of her. And, I mean, I'm not out to crucify her, but come on, my office has to keep working. I obviously can't keep asking Mr. Woolard to continue to pay us. We should be done by now. Just isn't that complicated. The other thing I would ask is that in the interim, that there be an interim order for the start of school, that he is registered for school here, that he attends school here, and that we have an out-of-state visitation until the evidentiary hearing. And I think that is, given the severity of this, that severe sanctions are appropriate.
There was one for the 20th of June, and there was one for, I think, the 16th of July.
So, how old is the child, and what grade is the child going to?
He's 4, he's going into kindergarten, and he makes the cutoff in December.
In both school districts, which is why the parents both enrolled him. Because we expected to have a decision. I don't think I'm wrong on this. We expected to have a decision, so both parents enrolled in case however the court would decide.
The school my kids go to now, they already started school on Tuesday.
How old is the child?
He's 4.
So why couldn't you wait a year to start kindergarten?
Because he's gone to school since he was 1 year old, and he's really intelligent. I don't want to keep him back.
And
No, you're not keeping him back. You're gonna produce a child that is gonna be behind everybody physically and eventually mentally, and all the studies show that, because the child who goes to school when he's 4 and maybe just turning 5 will always be behind.
He turns.
I'm not gonna argue with you. I'm just telling you what the studies show.
So he turns 5 September 12th.
Yeah, he's gonna be behind, because some people are gonna be 5 for almost a year by that time. So those people are gonna be 1 year older than your child.
So
I can't grant a default, but I can grant a continuance, and I can grant attorney's fees. But I'm not gonna grant attorney's fees today. I'm gonna have her prove what she says she can prove, which she has not proven. What's the earliest date we can have this case? And
I also.
ma'am, you should get an attorney. You know that?
I know. You know what? I don't have the money to.
Okay. Okay. You're like gonna represent yourself in a very important case involving custody of your child, where there's very complicated standards that you have to meet, and good luck.
Well, I'm sorry if I can.
I cannot help you. I can lean backwards and try to help you as much as possible, but when you're going up and against an attorney in a case like this, it's going to be very difficult for you to meet your standard, and you have the burden.
If I have if I can get 90 days, I can get an attorney from legal.
You know what? I think I've heard that before.
Well, I took a
I
class.
think I've heard it like several times from you.
No, not for me.
Okay. Well, we're going to have a continuance, so you'll have your 90 days
Okay.
again, because I've heard this several times.
No, I've never stated
So
this.
you're never going to get an attorney before? You never said that?
No, never. I don't have the financial means to do that.
Have you gone to Southern Nevada Legal Services?
I went there and I took a class so that I can get free legal aid, but we only had 30 days till our evidentiary hearing, and then it got postponed again. So I could have had a lawyer by now, but I didn't do that because I thought we were going to have our hearing. And it keeps getting
Earliest we
postponed.
have, half day would be October 10th, that's a Friday. The following week, we're also going the 17th.
I think I'm in trial on the 17th. But
I also, I also filed a motion for an order to show cause. The father, he broke our last custody order by claiming my son 3 years in a row.
By
And,
what?
I'm sorry?
By why?
He claimed for taxes, he claimed my son as a dependent for 3 years in a row, and it clearly states in our last order that we are to alternate every year, and that
We can hear that later, because, I mean, there's not going to be any more tax returns till April.
no, I'm being charged $6,000 because of it.
Okay.
And
But in the whole scope of things, that's not the very important thing right now.
it's from the year 2012.
On the October 10th, we have a magistrate arraignment.
Well, she wants 90 days. She needs 90 days. 90 days from today.
Your Honor, the other option for her to get an
August,
attorney would be
September.
the bar's reduced fee panel. If she went to the Nevada bar, she could fill out the financial form. She could actually get an attorney through the bar at a heavily reduced rate.
If I got my taxes, I would be able to retain a lawyer anytime. $6,000 they're charging me for that.
Well, charging you and paying is two different things.
Right, I should receive it any day, my tax return. I mean, because I showed my order and I proved everything. So any day now I should get that money. But other than that, I make $542 a month. I have 3 children.
What's the date?
You wanna go to November?
Yeah, because she needs 90 days, and she's going to need 90 days.
Southern Nevada Legal is out 6 months right now, because I do pro bono from them too, and I'm just telling you, unless she has an attorney that's willing to take it through pro bono, I think if we're really looking at 90 days, your better option is to go to the bar and do the reduced fee panel, and make sure they know that I'm opposing counsel because I'm on the panel.
It's November
Right, I invited
21,
you some.
that's a week before Thanksgiving. And that's a Friday at 9:30.
I'm open.
Okay, well, give them that date. I'll be right back, and we'll discuss her motion regarding the tax returns. Have you filed an opposition? Have you got the motion?
I saw the motion, when I was looking to see, I saw that it had been filed, I haven't received it. So I didn't file an opposition. I've talked to my client. If you don't mind, I would present opposition in court. There's not much to it. And then you can decide what you want to do with it.
Okay, do you mean present today?
If that's what you're choosing to do, I've already talked to him about why you took the tax deduction.
Okay. So go ahead and make your argument as to what your motion is.
I filed a motion, for an order to show cause. It was contempt of court. I have the order right here for,
You always keep pointing down there, but when I ask for
I'm sorry.
something, you never have
Okay,
anything.
Let me get my order.
Let me take a recess and I'll go get your motion.
Okay.
All right.